Yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. Appreciate you being here today. You may not have wanted to be here, but we did. I want to take just a moment before we get started and basically talk about our procedure here and how things theoretically are supposed to work. Each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, you may request that from the court after you've come up to the podium and introduced yourself. But before you begin your argument, you may reserve up to 5 minutes of rebuttal time. I know most folks here are experienced practitioners, but I feel better telling you about this. We have a lighting system on the podium. There are 3 lights on the lighting system, green, yellow, and red. Once you begin your argument, the light will turn green. Once the light turns yellow, you are running out of time. And once the light turns red, you're out of time. So we ask that you please respect those time constraints. One very important thing for everybody to understand is that we are live streaming these oral arguments. That doesn't sound like a big deal, may not be, but what I want you to understand is once you say it, it's going out to everybody who may be watching this, and it's out there forever. So think about what you say before you say it. That way we don't have to worry about anything there. I want to introduce our panel for this morning. We have Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Ms. Angie, anything we need to take up before we call the first case?
No, Your Honor.
All right, you may call the first case, please.
City of Memphis versus Malcom Gary.
Good morning.
Good morning, Your Honors.
Pull
Justice
that down,
Stafford,
pull the mic down a little bit.
Justice Stafford, Justice Golden, and Justice McGee. May it please the court, my name is Barbarette Davis. I am a senior assistant city attorney for the city of Memphis, and I represent the appellant in this case before you. May I reserve 2 minutes?
2 minutes,
rebuttal?
yes, ma'am. You may proceed.
The matter before you involves the applications of Mr. Malcom Gary, who sought line of duty disability benefits pursuant to the city's pension ordinance. Mr. Gary was a fire driver with the City of Memphis Fire Division and filed 2 applications, one on September 28, 2016, the second on November 20th, 2018. And these applications were based on a injury to the left wrist and an injury to the right knee. This case has a lot of twists and turns procedurally. Mr. Gary was notified by letter of a denial of his requested benefits after the case was administratively closed 2 times for his failure to adhere to the protocols of the city's process for seeking the benefits. Mr. Gary refused to present himself for IME evaluations, independent medical evaluations, on 2 occasions. And the city had no choice but to administratively close his case and send him a notice that his benefits were denied. The city asserts that the decisions of both the ALJ, George Brown Jr., and the Chancellor, Joe J. Jenkins, finding that he's entitled to the benefits were arbitrary and capricious, and that substantial evidence does not support their decisions.
Was there only one denial of benefits here?
There was only one denial. The case was initially administratively closed, and nothing happened after that until he filed a second application on November 20th, 2018.
What does it mean when a case is administratively closed?
What that means, Your Honor, is the city's third-party administrator, Gen X, was unable to get Mr. Gary to participate in the process. The city has a third-party administrator, and that third-party administrator is the way that these processes are completed. They gather all the medical evidence of the employees. They set up the appointments with the IMEs. They send the notices to the employees regarding their appointments with the various IMEs. And in this particular case, over a course of months, after the first application was filed and Mr. Gary refused to go to the IME evaluation, the case was administratively closed. Now, there were evaluations. There were 2 IME evaluations, one with Dr. Gill and one with Dr. Sokoloff. He went to those evaluations. Those were completed. Those doctors informed the third-party administrator, Gen X, that their opinion was that Mr. Gary was not disabled. But because Mr. Gary participated in the city's on-the-job injury program and also had 2 treating doctors, the city obtained medical assessments from those 2 doctors. Those 2 doctors submitted their medical assessments to our administrator. Dr. Christian Fahey was the treating doctor for his risk, and Dr. Christopher Ferguson was the treating doctor for his knee. The medical assessment from Dr. Fahey indicated or opined that he was totally and permanently disabled, and his disability was work-related or arose out of the on-the-job injury. However, the medical assessment that was provided by Dr. Ferguson, the knee doctor, opined that he was totally and permanently disabled. However, the injury was not, the disability did not arise out of the job injury. So, because there were not at least 2 qualified physicians, which is required by the city's pension ordinance, as this court found in the construction of this pension ordinance last August, the city did not have at least 2 qualifying physicians who would opine or who opined that Mr. Gary was totally and permanently disabled and the disability was based on his job as a firefighter driver.
So did Dr. Ferguson later change that opinion?
Dr. Ferguson later changed the opinion and determined that he was not disabled. That was in an assessment that he gave in August of 2021. In that assessment, Dr. Ferguson opined that Mr. Gary was not disabled, period. So the city was, that,
What about in his deposition? In his deposition, was his testimony consistent with which of those positions?
in his deposition, which was taken prior to the second assessment, he indicated basically the same. He indicated that that the knee injury was degenerative, a degenerative injury, and so he did not give a direct opinion regarding an assessment. What he basically said was he had degenerative joint disease, which over time continues to fail. So he didn't give a direct opinion. He just answered the questions that were asked of him regarding Mr. Gary's injury to the knee.
So in his deposition, did he express an opinion as to whether or not that that Mr. Gary's condition was work-related?
He expressed an opinion that the meniscus tear was work-related, but he also addressed the fact that he had prior arthritis that he could not assert was work-related.
Okay, thank you.
So you've talked about medical assessments and you've talked about depositions. What was presented to the pension board and what was presented to the ALJ?
The pension board, the way the process goes is the third-party administrator collects all of the assessments, provides those assessments to the pension administration. At that point, there are no depositions. What there are reports from the doctors, there are assessments from those doctors, and that information is given to the pension administration. In this particular case, what was given to the pension board were the depositions, the assessments, and the reports. Because in this case, by the time the pension board actually reviewed this case, the matter had gone before the ALJ. The ALJ reviewed it. The ALJ then sent it to the pension board, and the pension board reviewed all of the information, including assessments, doctor's reports, and the deposition testimony.
So the pension board reviewed everything that the ALJ reviewed?
That's correct, Your Honor.
Okay.
In this particular case, but not normally. Normally, the pension board does not review everything the ALJ reviews, because normally, if the case is approved by the pension administration, it goes directly to the pension board. This case only went to the pension board from the ALJ because the ALJ directed the parties to put this matter before the pension board.
Did it come back to the ALJ then?
It did come back to the ALJ. The ALJ overruled the pension board, determined that the pension board's decision was incorrect, and that based on the medical evidence, the ALJ believed that the benefits should have been awarded. My time is up.
No, you still got time. The light's still green.
Oh, I'm sorry. I'm looking at.
Was there a motion filed with the ALJ to dismiss this case?
There was a motion filed by the city to dismiss the case, and the basis of that motion was the city believes that the case was not right for the ALJ because Mr. Gary refused to present himself for a additional medical examinations.
Was
There
that
had
motion
been,
ever resolved?
pardon me?
Was that motion ever resolved?
It was resolved in an order in which the judge denied the motion and indicated that while Mr. Gary did not follow the letter of the ordinance, he followed the spirit of the ordinance in light of all the medical evidence. The city would assert that he was incorrect with regard to that decision because the case was not right for appeal because the city's process had not been completed by Mr. Gary. And so the city would assert that the decision of the ALJ as well as the chancellor who agreed with the ALJ was arbitrary and capricious because the city's process was never followed. Employees who seek these benefits should be required to at least follow the protocols of the city in order to get the benefits. Mr. Gary refused to do so, and for that reason, his matter was denied.
Is that the reason? I'm a little confused because I thought what you said initially was that he didn't have two doctors who said that he had a work-related injury that would not allow him to continue to work as a firefighter. But the chancellor found that Fay and Ferguson testified that his January 16 on-the-job injuries were work-related and left him permanently disabled and unable to perform the essential duties of a firefighter. Is that incorrect?
That is incorrect, Your Honor. As I previously stated, Dr. Ferguson determined the injury was work-related but not the disability because he found that the knee injury had pre-existing arthritis that impacted his disability decision-making.
Well, the chancellor went on to say that Ferguson sat for a deposition, provided testimony that the meniscal tear which he suffered to his right knee was clearly work-related, left him with permanent limitations, and that as a result he could not perform the essential functions of a firefighter.
But Dr. Ferguson also determined that the arthritis was a substantial factor in his disability
Well,
and during his deposition.
So if you have an injury, an on-the-job injury, and also have arthritis, in other words, it has to be, you can't have arthritis as a result of an on-the-job injury that would then disallow you from becoming disabled under the act.
I think what the doctor's opinion was that he could not distinguish the severity of the arthritis from the severity of the meniscus tear, and therefore he could not say that the meniscus tear itself was a disabling medical condition.
Thank you, ma'am.
Thank you.
You've got your rebuttal time.
Good morning, may it please the court. My name is Robert Spence from the Memphis bar, and I represent the appellee in this case, Malcom Gary. As you are aware, Malcom Gary was a firefighter. He devoted his life to fighting fires on behalf of the city of Memphis, and most importantly, one of the requirements to be a firefighter is that you have to be able to lift at up to, I think, 225 pounds. And that's because firefighters are often called to carry people out of fires or the equipment that they wear. And so being a firefighter requires that the person be physically able to do certain tasks. There's no question in this case. There is no question in this case that after Malcolm Gary suffered his injuries in 2016, that he could not perform the essential functions of a firefighter. There's just no question. The weight limitation that were placed on him by his authorized treating physicians, Dr. Fahey and Dr. Ferguson, was 40 pounds. And as a result of that, the city of Memphis didn't allow him to fight fires. So there's just no question that Mr. Gary, based on the limitations placed on him by the authorized treating doctors of the city of Memphis, could no longer perform the essential functions of a firefighter. During this case, the city asked Mr. Gary to be examined by Dr. Sokoloff and Dr. Gill. And both of those IME doctors, when they were deposed, agreed with Dr. Ferguson and Dr. Fahey. And so in this record,
Did they agree with him, or did they defer to him?
they deferred. That's more accurate. They deferred. They deferred to the opinion.
Why is there an issue about not doing or not getting IMEs here?
Yeah, I mean, that's an issue that the city continually raises. To what end, I don't know. Mr. Gary submitted to 2 IMEs. He submitted to Dr. Sokoloff. He submitted to Dr. Gill. And the city somehow takes the position that Mr. Gary had to submit to a 5th IME to ostensibly break a tie between Dr. Ferguson and Fahey and Dr. Gill and Sokoloff. But as we know from their depositions, they all really agree. They all really agree that Malcolm Gary, a firefighter, is disabled, has weight limitations, and can no longer perform the essential functions of the job. And so in this case, we don't, it's not one of those cases where we have 2 doctors that say one thing and 2 doctors that say something else. All the medical proof in this case, every bit of it, supports Mr. Gary not being able to perform the essential function of the job of a firefighter. And so the standard of review for the Chancery Court was looking at this record where all the medical proof, 100% of it, supports the decision of the ALJ. Is there substantial and material evidence in the record that supports that decision? In this case, since there was no countervailing evidence, of course there was substantial and material evidence in the record that supported the decision of the ALJ. And I believe that the Chancery Court made the correct decision in finding against the city's petition that the decision of the ALJ was arbitrary and capricious. It was most definitely supported by substantial and material evidence. The record is replete with that, and there's really not much dispute in this case between the parties as to the medical proof, because there is no countervailing medical proof. There is no countervailing medical proof. And as we all know, in order to establish injury and disability, and based upon the pension ordinance, you need physicians. Well, you need 2. Well, in this case, we have 2 plus 2 more. We don't have any contrary opinions in this case. And so the Chancery Court was correct in finding that there was substantial and material evidence in the record to support the decision, and I would ask this court to uphold that.
Let me ask you a question.
Yes, Judge McGee.
So, I haven't been through the record yet, but if I understood Ms. Davis correctly, she said that Dr. Ferguson's opinion was that Mr. Gary was disabled, but that it was not as a result of his work. It was not a work-related disability. Is that not correct?
That was not his ultimate opinion in this case.
So that was his opinion at one point, but he changed that?
Yes, yes. It changed over time. Dr. Ferguson treated Mr. Gary from 2009 forward. So he had the longest tenure with Mr. Gary. Mr. Gary had right knee problems beginning in 2009. He tore his meniscus in 2016. Dr. Ferguson replaced his kneecap in 2019. And so he had a long history with Mr. Gary. And over time, he submitted certain forms to the city that said different things. Some of them conflicting. But when Dr. Ferguson gave his deposition and under oath gave testimony, his testimony was that Mr. Gary can no longer perform the essential functions of a firefighter due to injuries he sustained as a firefighter, and that the weight limitations that he imposed on Mr. Gary, which he originally was 10, then he moved it to 40, are the result of the injuries he sustained as a firefighter. So the record in this case, the medical record, is 100% supportive, 100% supportive of the decision that the ALJ made, and that includes Ferguson, Fahey, Gill, and Sokoloff. All of them support the opinion, and as Judge Golden reminded me, Dr. Gill and Dr. Sokoloff, when they were under oath and had to testify, they deferred and they said, look, we defer to the opinions of the treating doctors who've been treating Mr. Gary for years. I think Dr. Sokoloff saw Mr. Gary for 4 hours on one occasion, and Dr. Gill saw Mr. Gary for 2 hours on one occasion. So there is substantial and material evidence in this record, which is the standard of review applied to the record by the trial court. What was presented to the trial court? What was the record? Was it substantial and material? And I submit to you that it was, and I would ask this court to uphold it.
Let me ask you a question about
Yes, sir.
the procedure here, because to me, the procedure is extremely confusing.
Yeah, it's confusing.
This goes to the ALJ twice, is that accurate?
Correct.
So the proper procedure is it goes to the pension board, somebody's dissatisfied, it goes to the ALJ, and then goes to the Chancery Court.
Sorry.
So what was the problem here?
The problem was the administrative closure of the case. That when the case was administratively closed and it went to the ALJ basically found that the process wasn't complete, that the pension board needed to make a decision up or down as to whether or not it was going to grant or deny Mr. Gary's request. So he asked that the matter be sent back to the pension board for a decision, and along with that order, he said, look, bundle it all up, give the depositions, give everything to the pension board, let them make a decision. The pension board made a decision, they denied it, it then went back to the ALJ, he then reviewed the record, determined that they were incorrect, it was then appealed to Chancery Court. So that is the procedural process and how it ended up where it ended up.
And so I assume the second time it's before the ALJ, there's a motion to dismiss.
There was a motion to dismiss made by the city.
And what's the basis of that motion to dismiss?
The motion to dismiss was that Mr. Gary would not submit to a third IME. And because he wouldn't submit to a third IME, the city took the position that the ALJ lacks subject matter jurisdiction to adjudicate his appeal. That was overruled by the ALJ, and I think it may have been re-argued in the Chancery Court, but neither ruling was in favor of the city on that issue.
Thank you.
Thank you.
Your Honor, just briefly, Doctors Gill and Dr. Sokoloff deferred, but not to the opinion as to whether or not Mr. Gary was disabled and this disability arose in the job. The deference was given to those doctors as being qualified physicians who have the knowledge regarding each of their subject matter medical areas to give testimony and make restrictions as regard to this particular patient. And so the city's position is their deference has nothing to do with their opinions as to whether or not Mr. Gary was disabled or not. As to the fact that he can no longer perform the essential function of the job, that is not the requirement of the ordinance. The ordinance requires that there be a finding that his injuries were disabling and the injuries on the job were disabling. And the city maintains that that issue has not been resolved because there is only one doctor in this record who has indicated that Mr. Gary's injuries to his wrist and to his knee
Ms. Davis,
are totally and permanently disabled.
the chancellor made a finding. It said, in addition, the court is mindful that the two physicians who performed independent medical exams of Mr. Gary, Doctors Sokoloff and Gill, largely deferred to Doctors Fahey and Ferguson regarding their opinions on Mr. Gary's permanent disabilities and whether he could perform the essential functions of the job. Is that incorrect?
That is incorrect.
Incorrect?
The city would assert that that is incorrect, that the deference that was given by those doctors were not as to the opinion of whether the injuries were disabling as it related to his job. That is incorrect, Your Honor.
So we can read the depositions and make a determination as to whether that's incorrect or not?
That is correct, Your Honor. And so the city would ask that the decision of the chancellor be reversed, that this matter either be sent back to the pension board for an adjudication or finding as to whether Mr. Gary is or is not disabled under the pension ordinance, or that you just totally reverse it. The city is not in the business of not granting eligibility to the employees who follow the process.
Thank you. Thank you, counsel. We appreciate your argument. We will take this matter under advisement and attempt to render an opinion to you at the earliest possible time. You may be excused.
Thank you, sir.